Pooja, the Supreme Court has asked for very simple information in the account of the companies concerned and the political parties concerned. And therefore, for this information, asking for any time appears to be very strange. All it requires is to go to their bank account and sort on the date when the bond was purchased and compile that information and provide. So that shouldn't take any time. There seems to be a certain reluctance. They are not there for genuine charitable or pious purposes or to promote the democracy in the country. That's not what the companies are concerned about. They they have businesses to do with the government. They have orders to be taken, contracts to be signed, supplies to be made.
The State Bank of India has sought an extension in the deadline to submit details of the electoral bonds. Joining me now is somebody who knows the scheme extremely well. Mr. Subhash Chandra Garg is the former Finance Secretary of India, but more importantly, he was the Economic Affairs Secretary when the scheme was launched. Sir, I first of all thank you very much for joining us.
Thank you, Pooja. Pleasure.
My first question is, do you think the State Bank of India has sought an extension of the deadline for it to provide the information on electoral bonds, the details of it? Now, if you could explain to us, does it really take this long to collate the information that the Supreme Court has actually asked for?
So, Pooja, the Supreme Court has asked for very simple information. One, from the buyer side, that who are the buyers who bought the electoral bonds, on which date and for what amount. They've also said denomination, but denomination is not very important. Amount of the electoral bond bought by the buyer is what is more important. They have also asked another simple information, that which political party deposited how much of the electoral bond with the State Bank of India on what date. Now, these information are the information which are readily available in the account of the companies concerned and the political parties concerned. And therefore, for this information, asking for any time appears to be very strange, unjustifiable. This information can be given in a couple of hours. That's it. By the way, Supreme Court had earlier asked for the same information in the interim order in 2019, and the SBI had supplied that information, though it was supplied in sealed cover. So at that time, they had not asked for any time. Would the SBI's petition in the Supreme Court asking for more time, there appears to be an attempt to confuse the issue, so to say. They have said we have the KYC related information on one silo and the political parties related information on another silo. The 22 odd thousand bonds have also been kept at some place in centralized location, and to sort of connect the buyers to the political parties will take time. That information, by the way, has not been asked for by the Supreme Court. And if for something which has not been asked for, why are you asking for time? And in my judgment, that connection between the buyer and the political party for each of the bond cannot actually be established at all. So they won't be able to do it even 3 months' time, 4 months' time. So it looks to be a very, very unnecessary attempt, basically to delay the submission of information.
We'll get to what you think the reasons are. But my question is, in another interview, you said that it takes just about 10 minutes, ideally, to compile the entire information that the Supreme Court has asked for. Now, if you could just explain to our viewers, what exactly does it take? What does the SBI really have to do to match and give the information that is asked of it?
So all the buyers have the account with the SBI, or if they had transferred the fund for buying the bonds from some other bank, or in very rare case, which is not likely to be the one, they bought the bond by sort of tendering cash, which is very unlikely. So, for all the SBI account holders, the information when you transact any from your bank account, all the transactions are recorded in your bank account, and it's all available at the click of the button. So you can take today the statement from for 1 year, 2 year, 5 years, whatever. This is so easily, everything is electronically available. So for all the buyers of the SBI, all it requires is to go to their bank account and sort on the date when the bond was purchased and compile that information and provide. So that shouldn't take any time. For those who sort of paid through some other banks by IMPS or RTGS or whatever other method, or by tendering a check, again, that information, because that transaction information is recorded. X of, let us say, Canara Bank or some other bank bought. So the SBI will have the information that this bond was bought by this person and paid through the Canara Bank account. So that information is readily available. It may be 10 minutes. That 10 minutes is a bit of a figurative kind of thing, but something which doesn't require any time. And for the political parties, by the way, that information is already available, because each political party has submitted the return in the sense that how much they have got it in the form of electoral bonds. That information is available publicly even now, which party got how much. So that information is it's only required to be arranged date wise. That's it. And that shouldn't be a difficult thing. So in my judgment, it's a routine. It's a very simple matter for getting this information.
Electoral bond scheme was in fact launched, the SBI had asked for a secret serial number to be included, which is visible only under UV light. Now, does this not make it easier for the SBI to put together all the information that the Supreme Court has asked for?
So, as you earlier noted, I was Economic Affairs Secretary at that time. The Economic Affairs Department is in charge of the electoral bond scheme. So, the proposal to have an identification number for the bond or each of the bond was actually it ran counter to the basic premise of the bond itself, because the bond scheme was designed in such a way that you can't identify which buyer gave to whom. That was the crux, the centerpiece of the electoral bond scheme. So if that is the basic premise, that is the basic condition, putting a number on the bond, and then that number being entered both on the buyer side and the political party side, would have killed the scheme itself. So there was no way this number would have been allowed, and that was the reason it was not allowed. What we did was that a kind of number is embedded as a security feature in the bond, but that is not visible, that's not identifiable. That number you can see in ultraviolet light or something, and that the reason for that was only that you don't end up getting some bond which was a fake bond. Otherwise, it's a simple stamp paper kind of thing. You can print it. There have been instances in the country where notes have been faked, or the stamp papers have been faked. Though the life of the electoral bond was not very large, which would not have encouraged, but still there could have been a possibility of someone coming out with a fake bond and that political party depositing in the state bank and getting paid. To ward off that possibility, that it was put in there to make sure that whenever the bonds are received by the SBI people, they can, if they want to verify that yes, this is the genuine bond. But that number was not entered anywhere, either at the time of selling the bond or at the time of depositing the bond. So today, If you were to take any bond and even identify the number, there is no way you can connect it to who bought this and who deposited.
A report by Reporters Collective, which is a news organization, has said that the SBI had shared all the details of the donors with the government, so with the finance ministry rather. So would it now, and it's also given it to the Supreme Court, like you rightly mentioned, in 2019. So what is stopping the SBI from doing so now? In about 4 to 5 years, what has changed in your opinion?
So I don't know this for sure whether the SBI has given any report about the donors to the government. It might be a speculation. I don't believe that this was the case. A lot of people had earlier expressed the apprehension that the information could have been given to the government easily because SBI is controlled by the government and SBI can do it. But as I explained a little while earlier, since you don't record the bond number anywhere in the system, it is impossible for the even the SBI to connect which bond was bought by which buyer and which political party deposited. The easiest information was that who are the borrower, who are the companies who bought the bonds. That is the easiest information available. That could have been shared with the government. I don't know whether this was shared or not shared. Officially, this was not possible. It was not allowed. The scheme itself said that the information relating to the purchases of the bond and the deposit by the political parties was not to be shared with anyone except to a court of law when the court of law orders it to be produced. Well, there may be certain connected money laundering or offences relating to the bonds. So you can't envisage a situation where the bond is not a property of a crime or something at any stage. So for that reason, the scheme provided that you can this is the only time when you share. Other than this, you are not supposed to share. So I wouldn't like to believe that the SBI had shared the information with the government.
But that said, they did share it with the Supreme Court in a sealed cover. So something has changed between 2019 and now. What do you think that is?
No, I would like to speculate, but very simple. If you go by the facts of the case, there seems to be a certain reluctance on the part of the SBI. Whether this reluctance is on account of its own motion or this has been the SBI has been advised by the government. You can only speculate, and you can also connect by the fact that they asked for close to 3 months plus by the time the election would be over, and therefore, if you connect all these dots, it looks that the attempt is to delay the furnishing of information to the court till the election are over. By the way, I have said very clearly that the order asking for this information uh, is not actually a very good order in my judgment, because this exposes the companies who were given a statutory guarantee, so to say, that this information will not be made available. The law of the land was amended, and that was the provision under which the companies worked. They had not earlier provided the political donations under that transparent scheme which still operates, that any company can directly or through the trust can give you. So, in my judgment, the while you might stop the electoral bond scheme, it should not have been asked that the acts done in the past, the bonds purchased in the past, that information should not have been asked to be shared. But that is not the case now. This is the law of the land. As I said, the Supreme Court has passed this order. Unless the government feels it necessary for asking of a review of the judgment, uh, only maybe for a comprehensive review, or to the extent that the information relating to these particular people who bought the bonds will not be that would be grandfathered, that would be saved. So that is what I think the government should be doing. If they are not comfortable for this information to come out before elections, at least they should go to the Supreme Court to ask for a review of the order, that this information about the bonds bought by the companies should not be disclosed. But if that is not asked for, asking the SBI, which is what I am inferring, the SBI might be acting on behalf of the government, that's not a right course to do.
I take your point of how the companies might feel misled, but just to play the devil's advocate here, sir, do the people of the country not have a right to know how much was given to which party? Because there is also this entire angle of possible pro quo because of the large donations certain companies made. So, what's your take on that aspect?
See, let us be pragmatic. The companies make political donations, and they make political donations for certain purposes. They are not there for genuine charitable or pious purposes, or to promote the democracy in the country. That's not what the companies are concerned about. They do make, they have businesses to do with the government. They have orders to be taken, contracts to be signed, supplies to be made, payments to be received, and many other things. And for these purposes, as a quid pro quo or even otherwise, the companies make donations. Now, they had been making donations earlier. They made the donations during the electoral bond period, and they will continue to make donations in times to come. The difference which the electoral bond scheme made was that the donations which was made earlier, largely in cash and an unaccounted form, was a lot recorded into the system. You had the bonds purchased from the legitimate banking sources and income of the company. The political parties also accounted for that in their own accounts and spent from there as a legitimate way, right? So while the electoral bond may not be the ideal way of political funding, in the sense you're saying that the people should have information, right to know, should know that who has funded whom, right? But if that state of idealism cannot be achieved in any case, and will not be achieved in times to in times to come, isn't it better to have at least 60%, 70% transparency in the system, and making it a white kind of situation rather than a black kind of situation, or a cash dominated? So while I agree that people have a right, and in a good healthy democracy this information should be available very transparently, who is funding whom. But given the situation in which we are, and this doesn't seem to be operating. By the way, people have also done certain kind of assessment that the total election related expenditure is actually much higher. So the electoral bonds might have covered 10% or 15% of the expenditure, but the other expenditure is much, much larger. And that still goes unaccounted. So even to the extent of 10 to 15%, if the electoral bonds have had brought limited transparency, in my judgment, that was a better situation than the situation which is otherwise obtaining when the electoral bonds will not exist.
I'm assuming you mean through black money coming in or through unaccounted for funding.
Absolutely. That is the way it was done earlier. Cash, black money, a shell company, or whatever. That was the way the companies would even convert their white money into sort of cash outside through different devices like underbilling, overbilling, and those kind of things, and then give the political donations. And those donations would end up with whom we don't know. So that was most intransparent kind of system. The electoral bonds brought some transparency at least.
So, just to summarize before we move on to other questions, you're saying that the information that the Supreme Court has asked for is simplistic because they've only asked for six bits of information, and that can be collated by the SBI in a matter of a few hours. Now, you're saying that they're confusing this with other information which takes longer, or in your opinion, cannot be collated at all. And they could be doing this at the behest of the union government. Have I understood you correct so far?
So I'm not imputing this whether they're doing, because that information I don't have, but the circumstantial evidence suggests that the SBI is asking for time after the elections. It must be at the behest of some, maybe the central government. We don't know, but this is only speculating because SBI has nothing to do with that. They are not required to invent that kind of excuse that we'll connect and something which they will never be able to connect, right? So the which bond was bought by whom and was given to which political party, that information is not required, and that information cannot be collected. So it looks like it's an excuse only to get time until the elections are over.
Right. I have two quick questions on other issues. I'm sure you've noticed that southern states, particularly Kerala and Karnataka, and of course Tamil Nadu too, have been taking on the Modi government, asking for their share of the tax money. They're saying that the union government in the last 10 years or so have been denying them their share of the total central taxes. What do you make out of this allegation since you have been in the system? And how do you see this playing out in light of the 16 Finance Commission recommendations to begin?
So there are two dimensions to it. Number one, what is the share of total share of the states as a whole in the central government taxes? And secondly, how much of that pool or the share of states together is distributed amongst the states, and whether the southern states have been sort of discriminated against. So the first part of the question, where the share of the central of the states together in the central taxes, that the finance commission says 42%, now 41% after the Jammu and Kashmir was declared as a union territory. So that 41% is being sort of eroded by the government of India by converting many of the taxes into cesses and surcharges. For example, almost entire excise duty today has been converted into cesses and the surcharges. And once it is converted into cesses and surcharges, then it's not shared with the states together, states at all. So that share has been sort of reduced deliberately by the central government. Uh, and because of that reduction, all states are suffering, including the southern states. But the second part, where the state particularly has been denied or discriminated against by the government of India, is entirely untrue, because the government of India does not determine the individual share of a state. That share is determined by the Finance Commission from time to time. And from the 15th Finance Commission's report, there is a surprising aspect. While Tamil Nadu and Kerala did not see a reduction in their share, Karnataka, for some reason, had a very large reduction in its share. Now, why was it done by the Finance Commission is required to be investigated, and the the Karnataka government should better understand why this happened, because it was not, as I said, in case of other states, the reduction was not that sharp, and there was a provision which was built in fact, in the terms of reference of the 15th Finance Commission, when the population reference year was changed from 71 to 2011, that the action taken by, or the work done by the states in reduction of population should also be factored in, and which the Finance Commission factored, which neutralized the likely reduction for, as I said, let us say Tamil Nadu and Kerala. So we need not and should not blame the central government for Karnataka's plight. It should be better and understood and investigated, inquired why this actually happened. And then, if there is something which might have got missed, or some miscalculation got done, etc., then Karnataka can ask for a rectification. That happens sometimes. You miss some information, but that is what the case need to be made. There are other dimensions connected with these fiscal federal relations. Kerala has recently gone to the Supreme Court, arguing against the centre's tight control over the borrowings of the state. There are some other states like West Bengal, etc., who have also sort of alleged non-release of the centrally sponsored schemes, grant, etc. Those are different matters. But as far as the tax matter is concerned, I don't think there is a deliberate attempt by the central government to reduce the share of any particular state. They have done, as I said, a reduction for the states as a whole, but that is where everyone suffers.
Right. My last question is on the growth rate in India, and you've looked at the latest data, and you said that at around 4%, the second term of the Modi government has seen the least growth since 1991. If you could just explain this to our viewers, and also what do you attribute this to?
So I had done this computation from 1991 onwards. The growth rates recorded by each of the government in their tenure. We have luckily 10 years of the NDA government, before that 10 years of the UPA government. There were earlier somewhat smaller tenures also, but taking all that into account, the this is a fact. This is verifiable. There's nothing, you don't have to invent it or impute it. The growth of the second term of Modi government will not exceed 4.3% per annum. And this is the lowest growth of any government after 1991. Why it has happened? There are two reasons to my mind. Number one, the first year, that is 2019-20, was a very poor year from the growth perspective. The growth was only about 3.8% or so. And the second one is that in that COVID year, uh, the government sort of locked down the economy for one full quarter. And if you lock down the economy and the production suffers, production of goods and services, in that particular quarter, the growth plummeted by something like 23%, and for the year as a whole also the growth was negative. It contracted by 5.8%. So if you have one year of a very small growth of 3.8%, a year of a contraction, negative growth of 5.8%, despite the fact that the last 3 years have turned out 7% plus growth, on an average about 7.5% to 8% growth, the pulling down effect of the first 2 years make the average growth only 4.3%.
Right. I thank you for joining me today. It was a pleasure talking to you. And you did explain the entire